there, my name's Jon Hummel, and I'm with the National Foundation for Gun Rights. We're the legal branch of the National Association for Gun Rights. What we get to do is we get to find bad gun laws all over the country and sue because they're unconstitutional and restore the rights to good citizens like you. Today, I get to talk about a really cool win that happened in the gun community out of northern Texas. The case is VanDerStok versus Garland. What this case is dealing with is it's dealing with the new rule that the ATF released back in April. The new rule did a lot of different things. One thing that it did is it expanded how long FFLs need to maintain records on gun purchases. It added some new definitions for gunsmiths, changed some engraving rules for adding serial numbers, made it so that serial numbers need to be added to any gun left at an FFL overnight. Lots of different things, but one of the biggest things that it did is that it redefined frames and receivers. Basically, it said 80% lowers and parts kits sold together, those are actually firearms. And so that's complete baloney. And what this case did is it challenged that part of the new rule. So the reason it's called VanDerStok is because there were two individual plaintiffs in this case. One was Jennifer VanDerStok, the other was Michael Andrin. Others who are part of this case, Firearms Policy Coalition, otherwise known as FPC, and then Tactical Machining LLC were also plaintiffs in this. Tactical Machining is a plaintiff because they have a major vested interest in the outcome of this case. They are a company that creates 80% lowers. So this new rule, making 80% lowers firearms, changes their whole landscape on how they do business. So they really were interested in this case. And something that's happened recently for a few different people is that the judge has issued a preliminary injunction. Preliminary injunctions are something that the courts do to try and maintain the status quo. So if they see that a law might be unconstitutional, they might issue one of these. There's 4 requirements to be issued a preliminary injunction. The first one is substantial likelihood of success on the merits of the case. What that basically means is that there's a good chance you're going to win, which is why we like to pay attention to preliminary injunctions. It's because they're kind of a signal that, yeah, this is baloney and they are likely going to win. So hearing about preliminary injunctions are big news and good news at that. The other thing is that in order to get a preliminary injunction, there has to be a substantial threat of irreparable harm. What that means is that the plaintiffs, in this case specifically Tactical Machining, they would be very much hosed if this law stays in effect for the duration of the trial. Court cases take an extremely long time, the courts move slowly, and so preliminary injunction basically says we're not going to enforce this in now until the outcome of the case is determined, whether in the favor of the plaintiff or of the defendant. And so because of that, with this, Tactical Machining was ruled that they are no longer under this new rule. A little bit later in the second opinion, the court determined the scope, so basically determining how many people besides just Tactical Machining will be affected by this preliminary injunction. And at that point in time, what the court ruled was that the 2 individual plaintiffs, so the 2 individuals, Ms. VanDerStok and Mr. Andrin, those 2 would not be held under this rule for this time, and then also Tactical Machining and all their customers would not be subject to this new rule, which is great news. Another group was actually enjoined into this case, which means they were added on as plaintiffs after the case was started, and that is Blackhawk doing business as 80% Arms. What that means is they were added to the case because essentially they are the same as Tactical Machining. They're another group that creates 80% lowers and will be impacted in substantially the same way. So they're what's called enjoined to the case. And just recently in late October, the judge said that this preliminary injunction will also apply to them and their customers. So this is great news. Essentially what this means is that if you are a customer of Tactical Machining or 80% Arms or Blackhawk, you are not subject to this new rule. Now, I'd recommend before you go out and say, I'm part of them, I can do whatever I want, double check on their websites just to make sure they have all the different regulations and everything that the court ruling stipulates in that. So be sure to double check on that. But this is a huge, huge win for gun rights. A big part of this win is that it did not even mention the Bruin decision, which was a Supreme Court decision that came out earlier this year that totally changed the gun landscape for the good. It said that every new gun regulation or every existing gun regulation is only constitutional if it adheres to the text, history, and tradition of when the Second and 14th Amendment were added to the Constitution. So huge news with both those things. But this decision didn't even rely on Bruin. Basically what this judge said is he looked at the GCA, the Gun Control Act, and how Congress did give the ATF the authority to regulate firearms. Part of that authority did include frames and receivers. Congress also gave the authority for the ATF to regulate parts and kits and things like that, but the Congress did not award the ATF the authority to redefine those terms. Those terms were already defined in the GCA and what Congress said the ATF could regulate. And essentially, he looked at what the new rule said and basically realized that the ATF, in their own definition of redefining an 80% lower as a frame or receiver, they define it as something that can become or readily become a frame or receiver. And he just said, listen, something can't not yet be something and already be something. And so by your own language in this new rule, you have a contradiction, and because of that contradiction, you can't just change what things mean. So this is a great rule. Again, it's not final, it's just a preliminary injunction, but this does signal to everybody that stuff like this and ATF overreach is hopefully reaching an end. The reason we are really excited about this is because this ruling has great reach to help us in other lawsuits. One thing that we have a very vested interest in is the new pistol brace rule that's going to be coming out probably sometime in December, although we're not sure. They've already changed the date on that once. But we are ready to sue the ATF for this new rule that's coming out in December, because with this ruling and this preliminary injunction, we can point to the ATF's not allowed to just make up new rules whenever they see fit. This is a great signal to the courts and to what else is happening, that this is something that can't stand. The other thing that's important is the Bruin decision is still binding. It's still a Supreme Court decision, and there were no laws like this at the time of the founding and the ratification of the Second and 14th Amendment. So we're really excited to have more and more weapons in our arsenal to help strike down unconstitutional gun laws. So if you want to find out more about what we're doing, I would encourage you to go to gunrights.org to see some of the different projects and lawsuits and political fights that we're involved with. We also have a Facebook channel. We're on Twitter. We've got so many things. We'd love you to like, comment, and subscribe to whatever you're able to. And yeah, help us to continue in this fight to restore our constitutional rights. Have a great day.